crypto, the notion that SEC Chairman Gary Gensler is quitting has swept Twitter. John Deaton, an attorney who is in favor of XRP, predictions and guesses are widespread in the quickly growing world of cryptocurrency. However, when a famous individual like Ripple's CEO, Brad Garlinghouse, makes a remark, the crypto world stands up and takes note. Garlinghouse has said that XRP is in the same category as Bitcoin, even going so far as to say that XRP is the next Bitcoin. In delving further into his XRP vision, Garlinghouse established a grandiose target price of $10,000 for the digital currency. To many, such a number may seem implausible, particularly in light of market capitalization and the massive amount of money that would need to flow into XRP to attain this goal. However, the Ripple CEO soon responded, claiming that market capitalization has no influence on the value of a currency. This remark goes against popular thinking and initiates an intriguing discussion about the measures we use to evaluate cryptocurrencies. Garlinghouse's upbeat outlook on XRP may not surprise those acquainted with the digital currency's path and Ripple's larger goals. Ripple has continuously underlined the significance of cross-border transactions, remittances, and global payment infrastructures, all of which might benefit from the use of XRP. In addition, the business has created agreements with various financial institutions across the globe to demonstrate the usability and real-world application of XRP. Garlinghouse isn't only hyping the price appreciation potential of XRP as a Bitcoin replacement. Instead, he's implying that XRP's usefulness and acceptance might match, if not exceed, Bitcoin's. It is a future in which XRP is not simply another cryptocurrency, but is firmly ingrained in the world's financial institutions and processes. A fresh thread has been weaved into the complicated tapestry of the legal dispute between the U.S. Securities and Exchange Commission, SEC, and Ripple Labs. Judge Annalisa Torres has granted her approval for the addition of an investment banker declarant, a move that had previously been met with opposition by Ripple owing to the law firm's involvement with the SEC. Andrew A. Kunsak, representing the prominent legal firm Sidley Austin LP, has been authorized to participate in the SEC's against Ripple Labs litigation. According to the court document, Kunsak's input is designed to guarantee that no secret facts get out, in accordance with an earlier court order that had sealed some material. This is specifically linked to the SEC's motion about the Hyman speech documents and Ripple's motion regarding its revenue information from XRP sale. Given the complexity of blockchain in the crypto world, such cases often go into areas where critical corporate or shareholder information may be jeopardized. The court's action seems to be a precautionary effort to protect such data, particularly given the SEC's determination to challenge a recent decision by Judge Torres. In a noteworthy turn of events, the SEC has filed a move for an interlocutory appeal. Their complaint is directed at Judge Torres' decision, which stated that XRP programming sales are not securities under the legendary Howey test. This is a crucial difference in the realm of cryptocurrencies, outlining the thin line between conventional digital assets and those that may be regarded as investment contracts, with the latter subject to stricter laws. As the legal drama unfolds, Ripple's chief legal officer, Stuart Alderodi, said that the SEC's current goal is to get a court order to file an appeal. Contrary to popular belief, they are not explicitly appealing the decision on XRP, appealing the decision on XRP's classification as a security. Timeline and justification of the appeal. David Schwartz, Ripple Labs' chief technology officer, recently discussed the latest development in the company's legal battle with the United States Securities and Exchange Commission. A post on X previously Twitter. A post on X previously Twitter. Schwartz's observations are timely in that they provide light on the SEC's reasoning for its recent appeal. Schwartz summarizes the SEC's approach, which centers on the Commission's belief that the litigation has not yet come to a conclusion. This view implies that parties have discretion to file appeals after the completion of the case. The primary goal of this strategy is to streamline the judicial system by preventing the main proceedings from being constantly sidetracked by several appeals on subsidiary rulings. The appeal arose following the crucial ruling by Judge Annalisa Torres on July 13 that XRP is not a security, even when traded on cryptocurrency exchanges. Although the judge ruled in favor of Ripple, the SEC is appealing on the basis of a new legal theory. The problem of parallel proceedings. Schwartz stresses the need of merging appeals and argues that separate appeals might extend the judicial process unduly. However, the current situation presents a complex obstacle. The SEC's position is that this case presents unusual circumstances that call for a departure from the norm. They want to halt the main case until the appeal is heard and decided. Ripple's conviction, though, is unshakable. Until an appeal, the principal case should continue. This approach is consistent with the judicial predilection for moving the main trial forward and dealing with appeals as a whole once the major case has been resolved. In addition to these procedural nuances, Schwartz also felt it was important to clarify rumors that were circulating within the Bitcoin community. There were rumblings that the SEC would appeal Judge Torres's judgment to a higher court. The outcome of the courtroom drama hinges on whether or not the appeal will be admissible, which may significantly alter the trajectory of Ripple Labs' case with the SEC. Linda Jones, a well-known Wall Street veteran, predicts a big rush of institutional money ready to join the XRP market, although the timing remains undetermined. Due to the continuing legal struggle between Ripple Labs and the U.S. Securities and Exchange Commission, SEC, XRP has been a recurring issue among experts, drawing significant interest in 2023. The essence of the issue is the SEC's claim that XRP sales, both primary and secondary, qualify as investment contracts, implying that XRP should be classed as a security. If this accusation is shown to be accurate, Ripple might be accused of executing an unregistered securities offering for more than $1 billion. Furthermore, XRP would be subject to SEC regulatory scrutiny. Numerous experts and XRP supporters say that the long-running legal fight has considerably lowered the token's price. However, Linda Jones believes that institutions would eventually drive XRP's value higher if greater legal clarification is supplied. Although Judge Annalisa Torres recently ruled in Ripple's favor, declaring that secondary XRP purchases do not constitute investment contracts, the legal procedures are far from over. Jones emphasizes the role that congressional legislation would have in raising the price of XRP. In my opinion, institutional money will drive XRP's price higher, Jones says. Legal clarity and structure are required for institutions. One crucial component was the litigation. More congressional legislation is required, but it will be passed. The money will then pour in a massive wave. They're getting ready. While the current legal battle between Ripple and the SEC has brought some early respite for XRP, the final outcome and market direction will be determined by future legal developments. The involvement of institutions and the passage of congressional legislation to provide a clearer legal framework are believed to be critical in unlocking the potential of XRP and drawing significant investment into the digital currency. As the market waits for clarification on XRP's regulatory status, focus shifts to the acts of institutions and politicians whose choices will influence the future of Ripple's asset and possibly release a tsunami of wealth into the XRP ecosystem. According to the SEC complaint, Ripple Labs generated more than $1 billion via the sale of unregistered securities. According to the SEC, XRP is a security since it was marketed by Ripple as an investment contract, which is a sort of financial instrument that allows investors to benefit from the efforts of others. The action filed by the SEC is based on the Howey test, a four-part examination used to evaluate whether a financial item is a security. The following questions are asked on the Howey test. According to the SEC, XRP fulfills all four sections of the Howey test. According to the SEC, XRP investors place their money at risk in the hope of profiting from the efforts of Ripple Labs and other third parties. The SEC further claims that XRP is a common enterprise since it is used to enable Ripple network transactions.